prosecution of the lead prosecutor appointed by the state, Mr. Dana SC, at the instance of the first accused, Mr. Zuma, and Mr. Zuma's request that I should remove Mr. Dana as prosecutor, all viewed in the light of findings and comments I had made in previous judgments in this trial. These findings pertain in particular to the events which have given rise to and conclusions that I have expressed regarding the merits of the alleged contraventions of the National Prosecuting Authority Act, on which the private prosecution is based, and which will arise again for consideration in deciding whether Mr. Dana should now be removed as prosecutor because of the private prosecution which has resulted. Perhaps just by way of some background, subsequent to the trial on the 1st of August 2022 being adjourned to 17 October 2022, Mr. Zuma commenced private prosecution proceedings against Mr. Dana and a journalist, Ms. Morn. The charges forming the subject matter of the private prosecution include an allegation or an alleged contravention of provisions of the NPA Act, specifically that Mr. Dana had disclosed alleged confidential information relating to Mr. Zuma's medical condition to Ms. Morn. Mr. Dana and Ms. Morn have since appeared as accused in the private prosecution in the High Court in Pietermaritzburg on the 10th of October 2022, and that trial has, I've been told, been adjourned to March 2023. In an exchange of correspondence prior to the last appearance in this trial on the 17th of October 2022, Mr. Zuma's attorney, in a letter dated the 16th of October 2022, recorded, and I quote only the relevant or material parts thereof, "We are instructed to register our client's objection to any further involvement of Advocate Dana in this matter. As you are no doubt aware, Advocate Dana is accused number one in the ongoing private criminal prosecution in which our client is the prosecutor. He appeared in the very same Court A on Monday, 10 October 2022. He is therefore ethically and professionally bound to recuse himself, as he is clearly conflicted. For now, we leave that issue in the hands of the court to regulate in the exercise of its own management of the proper administration of justice. In any event, the legal stance adopted by Advocate Dana is legally untenable. At the appropriate time, and should sanity not prevail in that regard, the issue of the apparent and unlawful insistence by the NDPP to continue to assign Mr. Dana to this prosecution will be appropriately dealt with." And there ends the quotation. At the last hearing, that's on the 17th of October 2022, Mr. Zuma's counsel specifically requested that I rule mero motu on whether Mr. Dana could and should continue to participate in the trial, given the private prosecution against him. I inquired at that point whether it was appropriate that I decide these issues in the light of my findings regarding not only the merits of the complaints giving rise to the private prosecution, but also other findings and comments I had made in the context of some of the remainder of the 14 grounds of alleged misconduct, which Mr. Zuma had raised in the special plea as pointing, so the argument went, to an alleged lack of independence and objectivity on the part of Mr. Dana, and which he contended would disqualify Mr. Dana from prosecuting. Just briefly on that, it will be recalled in my main judgment on the special plea that I had concluded that what was before me for determination was solely the special plea pursuant to the provisions of Section 106(1)(h) of the Criminal Procedure Act. Proceeding on that basis, I had found that a narrow interpretation of the phrase, quote, "title to prosecute," unquote, in Section 106(1)(h) was the correct interpretation to adopt. Accordingly, the 14 grounds of alleged misconduct relied upon by Mr. Zuma did not, for the purposes of Section 106(1)(h) of the Criminal Procedure Act, affect Mr. Dana's title to prosecute. I concluded in my judgment that these grounds of complaint might, at best for Mr. Zuma, affect the question whether he receives or would ultimately have received a constitutionally fair trial. Significantly, however, I found that if I was wrong in that regard, and that what was properly before me was an application for the removal of Mr. Dana, and or that the wide meaning of the phrase title to prosecute contended for by Mr. Zuma was the correct interpretation of Section 106(1)(h) to adopt, that the 14 grounds were nevertheless devoid of substance and had to fail. In reaching that conclusion, I rejected these grounds in many instances on the facts, and I made findings and expressed certain, it's been called even very strong views. The collective impact of my comments in those respects cannot be ignored in the context of this present judgment. I should add that I have for some time been concerned that these conclusions and certain comments expressed in my previous judgments might require my recusal. I was comfortable that the issue would not arise while the appeal processes were being exhausted. The appeal processes all having been exhausted, the stage has now been reached where the criminal trial should proceed. But there's now also the very real additional issue whether it would be appropriate and achieve a constitutionally fair trial, regardless of the eventual outcome of the private prosecution of Mr. Dana, for Mr. Dana to remain as prosecutor, or whether he should be removed. And most importantly, whether it is proper that this issue and matters related thereto should be decided by me in the light of the findings I had previously made. Having a situation where the prosecutor, Mr. Dana, is an accused at the instance of the accused, Mr. Zuma, who is prosecuting, is unique and novel. The implications and the impact thereof need to be considered very carefully, free from any views previously expressed on matters which may reasonably affect those issues. It is trite that I'm enjoined by my office, my oath of office, to ensure that Mr. Zuma receives a constitutionally fair trial, and that I must regulate the management of the trial to preserve the integrity of the trial and to ensure the proper administration of justice. The integrity of any trial must be beyond any criticism or reproach. It is my task to ensure that the current trial satisfies that expectation. A reasonable perception of fairness is all-pervasive. In the final analysis, the question of recusal invariably turns on whether it is factually indicated. Full confidence in the judicial system is essential for the preservation of the rule of law. Courts must not only be independent and impartial, but must be seen to be so. A requirement, if not explicit, then certainly implied in the Constitution. The present matter is not an instance where actual bias is alleged on my part. Mr. Zuma in his submissions expressly disavowed any reliance on actual bias. Our law regarding recusal, however, does not insist on proof of actual bias on the part of a judge. The appearance of a reasonable apprehension of bias is enough to vitiate the proceedings. Articles 2.5 of the Bangor Law Principles of Judicial Conduct and Article 13 of our own Code of Judicial Conduct are to similar effect. The issue is purely whether, in deciding the issues which will now arise, which I have endeavored to identify earlier, a reasonable apprehension of bias may arise because of the findings and views necessarily previously expressed by me. If such a suspicion is reasonably apprehended, then that means the end of my involvement in this trial. In President of the Republic of South Africa versus South African Rugby Football Union, reference was made to the judgment of the Supreme Court of Canada in R versus S, where the court commented on the situation where views are expressed by judges. and the following was said, and I quote, "Every comment that a judge makes from the bench is weighed and evaluated by the community as well as the parties. Judges must be conscious of this constant weighing and make every effort to achieve neutrality and fairness in carrying out their duties." Unquote. Accordingly, a judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of a litigant for apprehending that the judicial officer, for whatever reasons, but particularly the expression of previous views, might or reasonably will be perceived not to be impartial. A reasonable possibility of such an apprehension, as opposed to an actual probability, suffices. The relevant case law in that regard is also dealt with in my main judgment. The question whether Mr. Dana should remain as a prosecutor or whether he should be removed is inextricably linked to the merits of the criminal charges giving rise to the private prosecution. These include, inter alia, whether there was a leaking of medical information, whether the information was confidential, whether it was unlawful to disclose the information, whether the provisions of the NPA Act were in fact contravened, whether, even if not illegal and insufficient to result in a successful conviction in the private prosecution, Mr. Zuma's rights to a constitutionally fair trial would be adversely affected. As regards whether Mr. Zuma receives a constitutionally fair trial as guaranteed in terms of the Constitution, the factual premise underlying each of the 14 grounds of complaint previously raised by Mr. Zuma when advancing his case in relation to the special plea might also reasonably arise. At the stage when the special plea was being argued before me, Mr. Mpofu SC, representing Mr. Zuma, had sought an order, and I quote, referring the matter of alleged breaches of Section 41.6, read with Section 41.7 of the National Prosecuting Act 32 of 1998, to the Director of National Prosecutions and the Legal Practice Council for further investigation and appropriate action, unquote. This complaint was based on the aforesaid alleged disclosure of the confidential medical information of Mr. Zuma to Ms. Morn, the very circumstances giving rise to the private prosecution. I refused that request. I expressed doubt at the time whether the wide wording or terms of Section 41.6 of the NPA Act were necessarily constitutional and or would necessarily find application on the facts of this matter. I concluded further that it would not be unlawful for a prosecutor to deal with inquiries from the press to ensure that the public is properly informed of the work of the NPA, including, for example, progress made in prosecutions. This could inevitably involve the disclosure of information which comes to the knowledge of prosecutors in the performance of their functions and duties in terms of the NPA Act or any other law, and could hardly be prohibited by a blanket ban on the disclosure of all information in the possession of the NPA. The circumstances as placed before me in which the medical information came to be disclosed, allegedly unlawfully, are summarized in full in my judgment. I made a number of findings and expressed a number of views regarding the facts relating thereto. They included, inter alia, the following. I concluded that the intention by Mr. Zuma was that Dr. Mdujwa's letter of 8 August 2021, being the letter which contained the medical information, was to be used in support of Mr. Zuma's application for a postponement, which would mean that it was intended to become public in any event. I also concluded that the aforesaid conduct would be inconsistent with Mr. Zuma's protestations that the letter was a confidential document. I did not consider the information conveyed in the letter to be confidential. Alternatively, I said that in any event, the letter had been sent to the Department of Correctional Services and was to be filed in court as part of Mr. Zuma's application. Hence, that any confidence which might have attached thereto had been waived. That would be, notwithstanding the term, quote, medical confidential, unquote, appearing thereon, as no confidentiality was claimed when the letter was filed in court as part of his papers, nor were any parts of the letter redacted. I further expressed the view that the letter had been disclosed to Mr. Dana, Ms. Naika, and the DPP of KwaZulu-Natal, with any specific restrictions as regards confidentiality, by the head of the Correctional Centre at Escort on 8 August 2022, who seemingly did not view it as a confidential letter either. In my view, the letter, I found, did not contain anything confidential. Indeed, I described the letter of Dr. Mdujwa to be vague and general in its terms, as it did not disclose any particularity and did not mention any specific medical condition or illness Mr. Zuma is alleged to suffer from, which could be said to constitute a violation of his rights to privacy, especially given the purpose for which the letter was tendered. I agreed with Mr. Dana's description that the letter contained, quote, vague generalities, unquote. I found in the alternative that the disclosure of the letter might, at best, amount to an irregularity, but that it was not an irregularity which would result in a failure of justice and an unfair trial. I accordingly concluded that the disclosure of the contents of the letter did not only not deprive Mr. Dana of the title to prosecute, but that he also should not be removed as a prosecutor. Finally, I concluded generally, in regard to all the grounds, that on the evidence before me, it had not been shown that Mr. Zuma's rights to a constitutionally fair trial had been impaired, or that there was a reasonable possibility that his rights would be impaired. In regard to the pending private prosecution, which has now resulted, Mr. Zuma submits that it's inter alia constitutionally unacceptable for me to allow Mr. Dana to continue as the lead prosecutor in his, Mr. Zuma's prosecution, while he, Mr. Dana, is at the same time facing criminal charges in the private prosecution initiated at Mr. Zuma's behest, and that this court has supervisory powers which it must exercise to prevent such a situation developing, and that I, of my own volition, should remove Mr. Dana as prosecutor forthwith. It is undoubtedly so that irrespective of the outcome of the private prosecution, the fact that Mr. Dana is being privately prosecuted will require a determination of the question whether he should remain as prosecutor, whether that issue is raised mero motu or otherwise. The answer to that question will not only, viewed objectively and reasonably, be objectively important to an accused person in the position of Mr. Zuma, but will also reasonably affect the public confidence in the judiciary and the general administration of justice. The mere fact that a private prosecution is being pursued against the prosecutor in a pending trial by the person being prosecuted is a matter of considerable concern and might even strongly suggest that he should be removed as a prosecutor. But it is not per se, in my respectful view, necessarily conclusive of the issue, for reasons which I need not dwell on further in the summary. It does not mean that if there's a private prosecution that the prosecutor is necessarily involved in a personal crusade against the accused and must therefore, in all instances without qualification, be disqualified from continuing as prosecutor. There must be a weighing up of all the relevant considerations. Every case must depend on its own facts. The evidence and the relevant considerations must be assessed properly and dispassionately, and must be perceived to have been objectively evaluated as such. The choice of counsel is a very important consideration to any litigant. The choice is no less important where an organ of state, such as the NPA, institutes and pursues a prosecution. Regardless of the outcome of the private prosecution, the objective facts, however, are that I have expressed strong views contrary to the arguments advanced by Mr. Zuma in respect of the alleged unlawful disclosure of his medical condition. And these lie at the foundation of the criminal charge in the private prosecution, and the issue whether, as a result of the private prosecution, Mr. Dana should now be removed, mether motu or otherwise, from this criminal trial in which I am presiding. An objective accused person in the position of Mr. Zuma reasonably could not be expected to be satisfied, having a judge who has expressed views and made findings regarding the alleged leaking of his medical information by the prosecutor, and whether those constitute an infringement of his constitutional rights and a contravention of Section 46(6) of the NPA Act, now deciding, based on those very same facts which had been dismissed as devoid of merit, whether the integrity of the prosecutor has or has not been impaired to the extent that he should or should not be removed as prosecutor. The previous findings and comments made by me that will resume relevance appear from my previous judgments. That is also in relation to the 14 grounds which Mr. Zuma had previously advanced. Their significance will be apparent from the terms and findings I had made, and nothing further needs to be said about them in the summary. I had previously concluded that these 14 grounds of complaint raised by Mr. Zuma also had no merit. The views I previously expressed will reasonably be perceived, I believe, to influence findings which I will be required to make as to whether Mr. Dana should or should not be removed as prosecutor, and or in the future when the issue whether Mr. Zuma has received a constitutionally fair trial will arise for determination. Reasonably construed, my findings indicate that I have favored a particular interpretation of these factual issues, and they point to a reasonable and inevitable apprehension that when these facts and circumstances are presented before me again, they will be decided by me in a similar manner. A consequence of these findings might be that Mr. Dana should continue as prosecutor in the prosecution of Mr. Zuma. If that was to be my conclusion, with the result that Mr. Dana is not removed, then Mr. Zuma would be reasonably justified to feel aggrieved that a decision was made favoring the argument of Mr. Dana, dictated, or then at least very strongly influenced by my previous findings, in order to be consistent with my previous findings and the views I had expressed. I have come to the conclusion, and it was not an easy decision, that I have to recuse myself from the trial. It is what the sound administration of justice, the requirements of the Constitution, and my conscience dictate. The integrity of the judicial process must be protected against any reasonable taint of suspicion, so that the public and litigants may have the highest confidence in the integrity and fairness of our courts. The trial will therefore have to continue before another judge. This court shall adjourn briefly in order to be reconstituted. Please remain in attendance for that purpose, and it shall resume when the replacement judge shall enter court. That then is my judgment on that issue. Court will rise. Please.
Ms. Griffin. Okay. Thank you. Well, we'll chat privately. Yeah.
Protocol case number CCD 30 of 2018, the state versus J.G. Zuma and one other.
Please support the Lord. I'm here with my learned friends and my learned colleagues, Mr. Singh and Mr. Deploy.
As the court please, my lord, appearing on behalf of the first accused. My seniors, Mr. Paul, Mr. Masudu, not present today, but I'm here with the
Yes.
Please support the motion. Mr. Jackson, I, Mr. Bishop B, appear on behalf of the second accused and my friend is behind us.
Yes, I've been assigned to take over from my brother Koen. Where do we go from here?
Indeed, my lord. I do apologize for not introducing us to your lordship in advance, but given the circumstances, that wasn't practically possible.
Yeah.
My lord, you've asked the state to guide the court as to the way forward. And let me start off by saying, my lord, that we are here today for two reasons. The first reason was to get the judgment on the recusal, which we have now obtained, and the previous presiding judge has indeed recused himself, as your lordship is aware. So that is an issue which is now past us. The second issue was we were postponed until today pending the final order of the Constitutional Court in the first accused application in terms of Section 106(1)H. And in the intervening time from the 17th of October last year up to now, the Constitutional Court has indeed given its order, and it has dismissed the application for leave to appeal. So that issue, as far as the state is concerned, has now been resolved. And the reason for our meeting today, for our appearance today, was to decide what to do once that issue has been finalized.
Yes.
That issue has been finalized. Your lordship may or may not be aware, but we had all, as counsel and the previous court, agreed that the trial date should be fixed from the second term onwards to the third term, with the exclusion of some dates which didn't suit my learned colleagues, but that is a minor issue. So as far as the state is concerned, the stage has now been reached where the trial can continue, and that trial date was fixed on the 17th of April. And so our main application is that the trial should continue before your lordship as the new presiding judge, that the trial should indeed start and continue on the 17th of April. Your lordship will, of course, wonder what our attitude is to the threat or the indication that there will be another application from my learned friends for accused number one for my recusal. We, as the state, obviously are well aware of that indication from our learned friends, but we have received no application, despite the Constitutional Court judgment having been, or order rather, having been delivered last year. So in the absence of an application, we would urge your lordship to postpone today's proceedings to the 17th of April for trial. Your lordship is available. Well, I'm assuming that your lordship is available, but that's obviously...
I will have to avail myself.
You are, my lord?
Yeah.
Yes. So that being so, I would ask that the matter be adjourned until the 17th of April for trial,
Thank you.
as it pleases the court.
Thank you, Mr. Vitellis.
As the court pleases, my lord, my learned friend Mr. Downer correctly indicates that we had intimated towards bringing an application for his recusal, but that application would have been premature given the fact that we had this judgment by your brother Judge Koen, which was pending.
Yes.
Now that has been dealt with, and we can now say with certainty that an application for the removal of Mr. Downer is underway. So as to when that application will be ready, we'll look, but that application would come and should come way before the 17th of April. But in as far as they want to keep the 17th of April as a date for the trial to begin, we've got no qualms with that. As the court please.
Mr. Ring?
Thank you, my lord. Yeah, we're not involved in any application. Mr. Downer indicated there's some 2 or 3 days difficulty, but we should not raise that now. And the 17th of April was indeed a date set down, and I assume that we will get a chance at that day just to approach the court on 2 or 3 days of difficulty.
Will the accused persons be informed of the trial dates?
My Lord,
Because I see they are not before court.
yeah. My Lord, if I could assist your Lordship, I think I'm correct. My learned friends will agree with me that the previous judge, his Lordship's Judge Koen, at various stages for the various holding dates, ordered that neither accused need appear if they do not wish to, so they're excused from appearance, but on the understanding at each hearing that they will appear when the trial indeed proceeds. So that is the understanding, and that is the understanding that pertained today. May it please the court.
Yes. The matter that serves before me, a criminal trial, is adjourned to 17 April 2023.
May it please the court, Lord.
Court adjourns.